We'll get started. Thank you for all of you for coming. I'm A.G. Harmon, and I appreciate you attending the last of our presentations in this year's 2011-2012 Student Scholar Series. As you know, the series was instituted 4 years ago in order to recognize notable legal scholarship produced by members of the student body during the previous academic year and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Tara Beech. Before I introduce Tara, I'd like to first introduce the respondent for her presentation, Elaine Gardner. Ms. Gardner is the project director at the Disability Rights Project, part of the Washington Lawyers Committee for Civil Rights and Urban Affairs. She was also the former associate legal director at the National Center for Law and Deafness and is currently an adjunct professor here at the Columbus School of Law. We thank her for being with us today. Now let me introduce our presenter, Tara Beech. She's a graduate of the University of Pittsburgh. She received her undergraduate degree in political science. Prior to entering law school, Tara worked with the Constitution Project as well as Our Place DC, a philanthropic organization dedicated to helping formerly incarcerated women find employment. While in law school, she has interned with the Community Relations Service, the Office of Juvenile Justice and Delinquency Prevention, and the Bureau of Prisoners at the United States Department of Justice. And most recently, in her capacity as co-chair, she has been setting an agenda for the Criminal Justice Committee of the American Bar Association section on individual rights and responsibilities. Tara's interest in the subject she'll speak on today arose from her own life experience. As a volunteer with Our Place DC, she found that the former inmates seeking employment often had additional obstacles besides their past, including physical and mental disabilities. Later, as a staff member of the Journal for Health, Law, and Public Policy here at Catholic University, who nominated Tara's article for the series, she uncovered conflicting interpretations of the law over whether some independent contractors were protected from employment discrimination regarding disabilities. Her article explores this area and seeks to answer the questions arising therefrom. I'll now turn the floor over to the last of this year's student scholars, Tara Beech. The title of her presentation, Resolving the Split, Independent Contractors and Section 504 of the Rehabilitation Act. Tara.
Good afternoon. Just one moment to make sure that I'm set up. Thank you all for coming today. I think I just want to start with saying how much of an honor it is to have this opportunity and to be able to talk with you today about my ideas and about my note on independent contractors in Section 504. I want to start with just why the topic's important to begin with. And it really has to do with individuals with disabilities and independent contractors and their employment protections. And I first want to point out that there are 54 million Americans in the country with a disability, and that number is rapidly growing. Within the next 20 years, it's expected to double. And that's why it's important to have awareness of the workforce protections that are key for those individuals. In addition to being aware of those workforce protections, it's important to note that independent contract work can be a good thing for individuals with disabilities. It may provide more flexibility for the individual to manage their treatment and to be able to manage their symptoms, to learn how to manage their disability in an employment context, and to help transition into full-time work. And in addition to all of that, there's been a dramatic shift in our workforce from the employee to the independent contractor. In 2009 alone, there was an influx of over 400,000 temporary, contract, and freelance workers, and that number is expected to grow. And so as we continue to employ more independent contractors, we should be mindful that the individuals with disabilities that are taking that work have protections from discrimination. So as a roadmap, I'm going to discuss with you the disagreement in the courts over the employment protections for independent contractors. And the first thing that I want to do is to discuss the conflict in the courts and the law, the Section 504 itself. Then I'll move on to the judicial interpretations and how they conflict, and briefly discuss the call for congressional resolution, and then specifically talk about the resolutions that are proposed. Now, as an overview, There are two major federal laws that protect individuals with disabilities right now. Title I of the Americans with Disabilities Act, which applies broadly to most employers, and then Section 504 of the Rehabilitation Act, which applies more narrowly to entities and to programs and activities that receive federal financial assistance. Now, Title I applies only to employees and would exclude independent contractors, who would then have no recourse for disability discrimination claims under the Americans with Disabilities Act. That's not necessarily the case under Section 504. There is disagreement as to whether it does apply to independent contractors and whether they would be able to receive the same protections that the employees would receive. So, as a result, I think it's obvious that a resolution is necessary because of the inconsistent application across the country. And the note argues that the best methods of resolution is immediately in the lower courts. As the independent contractor client comes to the litigator, they should be pushing forward an agenda to make sure that in circuits where it hasn't been decided, that it is decided that it does include protections for them. And then the second resolution would be through congressional action, where Congress would need to amend the law to be more clear and to resolve the conflict that currently exists. Obviously, that takes a long time, which is why we want to start in the courts. I want to make a note that the Supreme Court's unlikely to act here, and they're unlikely to act because they denied cert in 2010 for Fleming v. Yuma, which was the Ninth Circuit case that allowed independent contractors to raise claims under Section 504. Sorry. Oh, I got this. There we go. So Section 504 is a simple provision. It says that no otherwise qualified individual with a disability shall solely by reason of his or her disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity that's receiving federal financial assistance. This piece of legislation was the first civil rights law for individuals with disabilities, and it was very simple, and it provided no more explanation than this. And until 1992, it didn't provide more elaboration. In 1992, the ADA went into effect, which was the expansive law for individuals with disabilities. And when it went into effect, Congress also amended Section 504, and they added Section 504D. And in doing so, they stated that the standards that are to be used to determine whether the section had been violated in a complaint alleging employment discrimination should be the standards under Title I of the ADA. And then it refers to the entire Act. And so I just want to get into the judicial interpretations here about what that means, because that section, 504D, the courts are in disagreement about what it means. And there's two camps about what it actually means. And the first is that Congress meant that it was supposed to be total incorporation. That the reference to the ADA was to incorporate both the substantive standards and the procedural standards of Title I. That includes the definitions and the limitations in scope, which means that Section 504 would apply only to employees. And then there is the second theory of interpretation, which is a substantive incorporation. And in the substantive incorporation, they say that only the substantive standards necessary to determine the violation should be incorporated. And to just explain what the substantive standards are in the ADA, in Title I, they describe a general rule in a section of construction. And they elaborate on what the meaning of discrimination is. They talk about a covered entity in the general rule and how it's prohibited from discriminating in regards to, and then they list a number of job-like activities. This is very different, and you can see why it's important to have this when, unlike Section 504, there's no definition of employment discrimination, and it's very broad. And so the incorporation is an important part of finding out what kind of discrimination and the definition of it. Now, under the procedural standards of Title I, they fall in the definition section. And these are the three that I've put up here for you today are ones that the courts have incorporated into Section 504. And they talk about the covered entity, the employee, and the employer. And it's important to note that when the ADA was interpreted, the definition section, because it involves the employee and the employer, courts said that it must mean that there's an employer-employee relationship, and therefore it's an employees-only law. And in addition to that, the employer definition exempts small businesses, employers that employ less than 15 employees. And so these are the things that have been incorporated under that total incorporation standard under the 6th and 8th Circuit that have really worked on it. And now we get to the actual judicial interpretation and the total incorporation. And the 6th and 8th Circuit really only use two methods of interpretation. They talk about comparison in one case, and they talk about the statutory scheme and analogy in the second case. And the opinions are very short. The analysis is thin. And for example, for the 8th Circuit, this is it. They say that the Rehabilitation Act only differs from the ADA because it requires the defendant to receive federal funds and it to be the sole impetus for discrimination. And because of that, and because they're substantially similar, the plaintiff must be an employee under Section 504 to bring a claim. That's the most they offered. They failed to recognize all of the other differences that exist between the two laws that the 9th and 10th Circuit recognize in their interpretation. And the second is the 6th Circuit, and they really look at the statutory scheme and analogy. And this isn't an issue of Section 504 referring to the ADA. They are actually referring to Title VII of the Civil Rights Act. But it's still very important and telling in this case because they're incorporating that same definition of employer. And what the court says is that Title VII's sister civil rights statutes, and they expressly name in that the ADA, the ADEA, which deals with age discrimination, and the Rehabilitation Act, borrowed the definition from Title VII into a definition of employer. What's really interesting about this is that Title VII, the ADA, and the ADEA all define employer in the statute expressly, and they all define it the same way. The Rehabilitation Act does not mention employer, and so you can only conclude that they're incorporating by reference, and they would incorporate by the same reference under the ADA, under the reference to the ADA for all of the statutory definitions because of the statutory scheme and analogous case law. Now, the substantive incorporation, as you can see, is much more comprehensive in their judicial interpretation, and they look at the plain language. They analogize, they look at the overall structure. They talk about how important it is to avoid inconsistency in duplicating terms. They talk about judicial restraint briefly, and they briefly mention the legislative history of the amendment itself. And so, as far as plain language goes, they quote 504D to say the standards used to determine whether this section has been violated. And they say that that word choice is indicative because it's not expressly referring to a section in the ADA that would limit the scope of the Rehabilitation Act, and there's no limiting language in the amendment itself. And therefore, they conclude that the incorporation of the standards is for the violation itself and not who's covered. Now, they bolstered their argument by analogizing to a Supreme Court decision that dealt with incorporation in Consolidated Rail. And Consolidated Rail was dealing with Section 505 of the Rehabilitation Act. And you can see the reference to Title VI in the law. And what the court said about the reference to Title VI in Section 505 was that it didn't incorporate everything from Title VI, which was talking about limitations. Because it doesn't refer to the language in Title VI that would restrict Section 505 scope, and there's no other limiting language. The court moves on after that to look at the overall structure of the two laws, and in Section 504, it applies to any program or entity. That means it applies to employment, it applies to education, and it applies to benefits and services. It applies to a student seeking education at a university, as well as a patient seeking services at a hospital. And it doesn't matter the relationship between the defendant and the plaintiff in those cases, or the size of the business, whether they can bring a claim under Section 504. Very differently, Title I applies only to employment, and it's very specific, and it also applies so broadly to most employers that it's really important to understand that these two laws rely on two very different constitutional footings, and it makes it obvious why one would be more broad than the other. And in Section 504, they're relying on their spending power, the Congress, when they pass the law, and because they can provide conditions for providing federal financial assistance, they can make the law broader than what the Title I of the ADA could, because it was relying solely on the commerce power, and they had to weigh the burdens that it was going to produce on the private entities over the advancement of the law itself. So they move on after that to talk about avoiding this inconsistent duplication, and it's again important to keep in mind where the laws are coming from and power of constitutional power and source. And as far as a covered entity goes, the Section 504 covers all operations of practically every entity you can describe, as opposed to Title I, which only covers the employment agency, labor organization, et cetera. And it's again limited in scope, largely because of where the laws, the power derived on passing the laws. And this definition of small employers is actually an inconsistency in the laws. Title I exempts employers from being defendants if they employ under 15 employees. Now, Section 504, in its language, exempts small providers from the requirement to make structural changes to their facilities. It makes no sense to have that language in the law if it's going to exempt all small businesses to begin with. And so it's a huge inconsistency that wasn't recognized by the 8th Circuit or the 6th Circuit in the total incorporation theory. Oh. So the court then talks a little bit about the legislative history and the Senate report to the amendment, and Senator Harkin, who was the sponsor of the amendment. And he stated that now those who are covered by Title V of the Rehabilitation Act will know that these definitions of reasonable accommodation and discrimination will apply. And he also says that incorporating the ADA standards into the Rehabilitation Act will assure that there will be consistent, equitable treatment for both individuals with disabilities and businesses under the two laws. There is nowhere in the language of the amendment or in the Senate report where they talk about limiting the scope of the Rehabilitation Act, and it's pretty clear from the language of the amendment sponsor that all they were trying to do was make the definitions for discrimination and reasonable accommodation uniform. So, I hit the wrong button. There we go. So, and this is just a quick note that the 9th Circuit wrote, and I think it is in response to how little work the 6th Circuit and the 8th Circuit did in analyzing the incorporation. And they say that the jot-for-jot incorporation in some respects is easier to administer than a selective regime, but their own administrative convenience isn't a factor in determining what Congress meant. And it is important to remember that when litigating these cases, that it should be pointed out how different these laws actually are. This is an additional interpretation that the courts didn't add, but I thought was important, which is that the purposes of the laws are also very different. You have the Americans with Disabilities Act, and it's supposed to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. It's obvious that it's a societal issue. It's a group. It's a big problem that they're trying to eradicate discrimination, and it encompasses a greater goal of a societal change than, say, the Rehabilitation Act and their purpose, which is to empower individuals with disabilities, to maximize their employment, and economic self-sufficiency and independence, and to ensure that the federal government plays a leadership role in promoting the employment of individuals with disabilities. This purpose is very individual specific. It's very focused on getting an individual with a disability to be self-sustaining, independent, and employed. And as a result, because they're not bound by the same burden balance that that Title I of the ADA is, they can require the entities that are receiving federal financial assistance to do more and to also be leaders in efforts. So I think it's pretty clear that the only interpretation that makes sense is substantive incorporation, and that the court should adopt it where they're not bound by contrary precedent. And I think it's also really important to note that it should be used as a practitioner's litigation tool. And this is important because the Eighth Circuit, in their opinion, faulted the parties for not citing persuasive authority. This doesn't have to be the case anymore. The Ninth and the Tenth Circuit have comprehensive opinions. This note lays out why the interpretation should be what it is. And as long as litigators are thorough with their litigation, they'll be able to back the court into a logical corner where at least they'll have to provide more comprehensive interpretation. Even if they are to go the other way, at least they'll have to work harder at doing it. And so the call for congressional resolution, which may happen a lot later, needs to be done because it's just good policy. And as I said in the beginning, the disability numbers are growing. The independent contract work can be positive for some, but it could be even more positive if they're protected in the work that they do. And this workforce shift between the employee to the independent contractor is a recognized issue, not only in the influx of jobs that have occurred, but in the misapplication. And both the President and Congress have been striving for harsher laws for misclassification. And huge companies such as FedEx have run into trouble with the issue on their own for misclassifying employees. And so that's another way to seal that gap and make sure that individuals with disabilities are getting protected. And then finally, this inconsistent application is just flying in the face of the efforts to make these laws consistent. And the 1992 amendment in Senator Harkin's response, or quote in the Senate report, really stated how important it was for everybody to know what the law was. And so the resolution I propose, I think I've pretty much explained to you the judicial interpretation, and that practitioners should use it now and advocate thoroughly, and that the court should adopt it. And the congressional amendment, Congress should amend 504D to either refer specifically to the substantive standards itself of Title I, or to exclude specifically the procedural standards of Title I. And that's it.
Now we'll ask Ms. Gardner if you conduct a response, and then we'll open it up to questions from the audience.
Thank you so much, Sarah. I thought that was very thoughtful and a great analysis of a very important issue. I had a few questions, really more like on a policy note. I was wondering, it is an important area. I mean, especially because more and more employers are classifying or sometimes misclassifying people as independent contractors. Why is it that your recommendation is that Congress would to clarify that 504 covers independent contractors? Why not something broader? Why not take Title I to the independent contractor protection?
I just didn't think it was likely.
Mm-hmm.
I would have loved to. As I was doing my research, I found numerous efforts to redefine employee, to redefine employer, and it seems as though the efforts aren't really going anywhere right now, and especially with the climate in Congress, this is simple, and it doesn't see. It can be argued both ways, that it has a big impact and that it's just such a small change, mm-hmm. that it might be easier to get through than saying let's open up Title I now that we can. But I would love to add that as a wish to open up Title
Thank you. Yeah, I kind of thought that would be your answer. Another question I had, I didn't see in any of the cases that you cited a big difference in 504 and Title I in employment cases, which I use all the time as a practitioner. And that is Title I, procedurally, Title I requires one to exhaust administrative remedies. You can't just go into court with a Title I case. You have to go through the administrative process. 504 cases are great. You know, if I have an employee of, say, Catholic University, I can just go right into court because they're a federal financial recipient. Their employer is a federal financial recipient as opposed to simply a Title I employer. That's a big difference. And, you know, clearly the 504 doesn't totally incorporate Title I because the courts have never had a problem with not requiring, you know, an exhaustion of administrative remedies for a 504 employee. Is there ever any analysis of that?
You know, I haven't seen it. But I think you're right that it is very important, and it's also important to underscore the government's role here, and when I was talking about the purpose of the law, which is to promote the individual, and it's not about, and they don't have that same balancing act that they have to do, and that's just proof that there's not the same balancing act that the Title I has.
Exactly.
So, yes.
It's just not as much, as it were, protection of the employer. They can be pulled right into court.
Right.
Yeah.
Right. That is something to add, definitely.
Could I have one more question?
Yes.
In reading these cases, and you know, again, my background and my slant is totally as a practitioner. I mean, that's the way I look at things. I look at a case, I think, is that the way I would have litigated it? And looking at these cases, say, you know, the case where the doctor is the plaintiff, and he is he's found not to be an employee, he's found to be an independent contractor of the hospital. Why would a lawyer not, if they're using Section 504, which has such broad protections for people with disabilities vis-a-vis federal financial recipients, why would you not simply forget about the employment, but just say, here is an individual with a disability who is being discriminated against by a federal financial recipient. I mean, the hospital is not permitted to discriminate against visitors with disabilities, patients with disabilities, companions of patients with disabilities. Anybody who enters that hospital cannot be discriminated against on the basis of their disability. So why would the doctor, even if he's not an employee, why would he not have a cause of action under 504 just as a person with a disability?
To be excluded from the benefits and services of. I think that the Ninth Circuit addressed it because it was a doctor, and they said that he was an independent contractor. They actually raised an ADA claim, a Rehabilitation Act claim, determined he wasn't an employee and that he was an independent contractor. But I think that there's also has something to do with the type of relationship, and that it was a contractual relationship. And I'm not positive, but I would guess that there's an analysis that it was he was deemed an independent contractor as opposed to just somebody receiving benefits and services.
Right.
But it's definitely something worth looking into to see how the other courts are dealing with it, and if they're not even mentioning the employment part of it.
Right, because it seems to me that if I, as a visitor of a patient at a hospital, have a right to bring my assistance animal into the hospital because I am simply visiting the hospital once in my lifetime, why should I have more rights than someone who goes into the hospital every day?
Right.
You know?
And I think it depends on what type of discrimination is being argued. And for the Ninth Circuit case, the doctor was excluded because he had bipolar disorder, and they took his privileges away for his behavior, and so he was unable to perform his job at the hospital as opposed to just go in. I don't know if they would have restricted his services as opposed to. I think it was still tied to this job function.
Do you think it was one of those cases where bad facts make bad law?
Likely. Likely.
You think if he had had an assistance animal, they would have had a little more?
Yeah, probably. Yeah.
Questions from the audience? First of all, I wanted to say I really enjoyed your paper and your presentation. I was wondering if you can think of some ways where relying solely on the substantive differences between the Rehabilitation Act and the ADA would in fact undermine protection under the Rehabilitation Act. So sort of what's the downside of your argument? Because we know the Rehabilitation Act precedents relies on a lot of the ADA precedents and then the ADA Amendments Act. So I'm thinking, there's tons of examples where the Rehabilitation Act is relying on ADA case law and so forth. So if you make that distinction and you take out some of the procedural, and you say that these are very different statutes, is there a downside to making that argument so strongly? What might you lose by doing that?
I think that as far as the uniform statutory scheme that the Sixth Circuit was talking about with the civil rights statutes, you would lose that uniformity in a way because everybody is all those other laws incorporated employer. It's also though really telling that the Rehabilitation Act doesn't expressly define it, and that they're incorporating it in without it. And it was also in existence well before the ADA, and it worked just fine. And in fact, it didn't come into problems for plaintiffs, at least, until the ADA had been enacted. And so I think that, if anything, it might return it back to a regular balance of where it should be. And the ADA really took, in some respects in the courts, before the Amendments Act, took a lot of rights away because individuals just couldn't get into court. So I think that it might be able to strike a balance in that respect. So, Sharon?
I'm curious, I know there's a lot of movement, as you mentioned, by employers to classify people as independent contractors and hire them, and I gather one of the reasons is you get out from a whole lot of laws by doing that. I'm curious, did you or do the courts at all look at that? Like, are there any comparable obligations that do still apply to independent contractors? I imagine, you can't pick them based on their race, or I don't know. Did either you or the courts look at what still does apply to independent contractors?
No, I don't have specifics. I know that as far as, really I think it's a tax thing and the liability issue. They're not liable for certain types of discrimination. I'm not sure if it would go into civil rights act stuff. I'm not positive there, but it'd be interesting to explore to see what protections they keep. And my inclination is none. So, Renee?
It's probably kind of a queen of the world question. So, one of the things that I've seen in my phase of my current employment is after the ADA was enacted, the initial employment of people with disabilities just plummeted because people saw them as a liability. There's a potential future lawsuit. We're just not going to hire them to begin with, particularly so in right-to-work states, which are a growing segment now of our society. If you continue to expand this to include independent contractors, how would you propose protection so that that same problem doesn't extend to, okay, we just won't give them the initial contract to begin with. We don't have to tell them why. It's up to them to then prove with no information that we've discriminated. How would you propose that be protected?
Well, I think that it's a smaller problem than what you think it might be because the ADA applied to everyone, and because this is applying to entities that are receiving federal financial assistance, and so it's a slow way to go. It's a way to get people used to the idea, and it's a tit for tat. They're receiving financial assistance. There should be conditions on it, and it should be they should be as much of a leader as the government in that role, and it perhaps could pave the way for future legislation.
And I think you'll notice in these cases, these are not people, for the most part, with big visible disabilities. I don't think they get the independent contractor jobs now. It's people with invisible disabilities who then are discriminated against and then bring these cases.
Right.
Any other questions? Well,
Wait, Steve.
okay, yes.
Any theory or speculation on why the Supreme Court didn't take cert on the case?
I have no clue, unfortunately. I wish I knew. I'd like to think that the Ninth Circuit was just that good, or, but that they didn't want to mess it up. But I have no idea. So.
Well, I'd like to congratulate Tara for ending. Boyd's presentation that we strive for, and she did a great positive, still very proud of her. We have a token of our appreciation for Tara. Thank Ms. Gardner for helping us today and do a great program. Thank you all for coming to the series right this year.
Thank you very much.